Hello everyone, welcome back to Master Stage. And today we are going to discuss Jurisprudence. It is part of LLB third semester, paper 1. So let us see what is jurisprudence, meaning and definitions. So the meaning is science of law, study of legal principles and theories of governing human conduct in society. So, in general, jurisprudence means it is a universal principles applicable all legal systems across different societies and nations. So, a particular jurisprudence study of specific legal system of a particular country or jurisdiction. So, according to the uh, definition given by Austin's Science of Positive Law and Holland's Formal Science and Positive Law. So, ancient Indian jurisprudence and schools. So, elements of ancient Indian jurisprudence, Dharma as foundation of law, like Vedic text and Smritis, Rajadharmas, that is the king's duty. Then Vyahara, that is legal procedures. Okay, so the schools of jurisprudence is different philosophical approaches to understanding law, its nature and application in society. So each school offers unique perspectives on legal interpretation and development. So there are four major schools of jurisprudence. Let us see. Here, one is analytical school. It focuses on law as it exists. So, emphasizes positive law and command of sovereign. So, key jurist, that is John Austin. Then it comes to the historical school. It see law evolves from customs and traditions, so it reflects what just that is the spirit of people. Okay, so here the key jurist is Savigny. Then third one is the philosophical school. It is concerned with the ideal law based on reason, morality and natural justice principle. Then sociological school. So law as a uh, social engineering tool focuses on social interest and welfare. Here, the key jurist is Roscoe Pond. Okay, these are the four major schools of jurisprudence. Do remember. Then, theories of law and severity. So, meaning of law. What is meaning of law? Rules of conduct recognized and enforced by the state to regulate human behavior. Then nature and functions. Okay, it's maintains order, protects rights, ensures justice, and promote social welfare. Then purpose and classification. So there's a public law, private law, substantive law, procedural law, civil law, criminal law. So these are the classifications of law. Then justice and equity and justice. So equity is a supplements of law. Justice ensure that fairness and moral rightness in legal decisions. Then what is sovereignty? So it is a supreme power of state, absolute, indivisible and inalienable authority over territory. So this is the theories of law and sovereignty. Then uh, we comes to the unit 2, source of law. What is the source of law? Legal sources, historical sources. Okay, so when you're writing, write this. Okay, then you will get the full marks. So legal sources, so sources from law derives its forces and validity, legislation, precedents, and customs. These are the legal source. What is historical source? Sources that provide content to law but lacks formal authority, like religion, text, and commentaries. So these are the source of law, legal sources and historical sources. So legal sources are authoritative and bonding, while historical sources are influence legal development without direct enforcement power. So you should understand this. Then legislation. So we'll see the definition. Definition here: process of law making by competent authority, most important source of modern law. This is called as legislation definition. Then supreme legislation, so made by sovereign power, cannot be repealed by any authority. That is called as supreme legislation. Then subordinate legislation, made by authority, subordinate to sovereign, subject to control supreme, uh, supreme legislature. Then direct legislature, so law made by directly by legislature itself through proper procedure. Then indirect legislation, what is that? Delegated legislation, authority delegate to executive or other bodies. These are the legislation. Then precedents. Okay, what is that? Precedent. So the definition is here: judicial decision serving as authority by deciding similar cases in future. So this is the definition of precedent. Then state diseases. So like doctrine of standing by decide cases, ensure that consistency and predictability in law. Then original precedent. So creates new law on matter not previously decided. Then declaratory precedents. So applies existing law to new facts without creating new principle. So authoritative precedents are binding, while persuasive precedents are mainly influential. These are called as precedents. So do remember and write in the examination. Then customs and codification. So what is customs? What is codification? We'll see. Custom, so long established practice observed as obligatory rule. So oldest source of law, like general customs, legal custom, and here general customs are applicable throughout the country. So local custom, it is limited to particular locality. So must be ancient, okay, certain, and reasonable, continuous. These are the customs. Then what is codification? Systematic arrangement of laws in written form. Okay, I repeat, systematic arrangement of laws in written forms. So what is the advantage of this codification? It is a certainty, accessibility, uniformity. Then what is the disadvantage? It is the rigidity, may become outdated. Though customs and prescription differs. Custom is usage, prescription is right acquired through usage. This is about the custom and codification. Then persons and personality. It is a part of unit 3. Meaning of person: being a capable of having rights and duties subject to legal relation. This is called as person. So nature of personality, so legal capacity to bear rights and obligation not limited to human beings. So special cases here: lower animal lacks personality, dead persons. Estates have limited rights, so unborn persons protected. These are the special cases, persons and personalities. Then legal persons and corporation. So what is legal person? Entity recognized by law as having legal personality distinct from natural person. This is called as legal person. Then corporate personality. So separate legal existence independent of members can sue and sued. This is like corporate personality. What is corporation person? Corporations artificial persons created by law with the perpetual succession and common seal. So the purpose is limited liability, perpetual existence, separate legal entity for business operations. This is the legal persons and corporations. So what is rights and duties? So rights are interested interest recognized and protected by law, so capacity to influence actions of others. So every right implies corresponding duty on others to respect that right. So here duty, it is a legal obligation to act or refrain from acting in particular manner. So duties may be positive to do or negative to abstain. Okay, rights and duties are correlative concepts. So one cannot exist without other legal in framework. So these are interrelated and interdependent rights and duties. Okay, then classification of rights and uh, Ohofelden concept. So absolute rights, relative rights, liberty, power, immunity, privilege. So absolute rights. So rights available against entire world, that is right to life, liberty, property. Okay. Then liberty, freedom to act without legal restraints. So absence of duty. Immunity, freedom from legal power of another. So protection from alternation of legal position. So relative rights. So rights available against specific person. Example, contractual rights. Then power. So legal ability to alter legal relations. Okay, create existing existing rights. Then privilege, special rights or advantages granted to particular person or class. These are the classification of rights and Ohofelden concept. Do remember. Then obligation. It is a part of your unit 4. Obligation is like nature, legal duty to person or legal duty to perform or abstain from particular act, binding force in person. Then contract. It is a obligation arising from voluntary agreement between parties with consideration. Quasi contract. So obligation imposed by law without agreement or prevent injustice enrichment. Then trust. It is a fee fiduciary obligation where trust holds property for benefit of beneficiary. Then breach. It is a failure to perform obligation leads to legal consequence and remedies. These are called as obligations. Then liability. What is the meaning of liability? Legal responsibility of one's acts or omissions, obligation to make reparation. Then civil liability, obligation to compensate for legal wrongs, remedies through damages or injunction. Then criminal liability, responsibility for offences against state, punished through imprisonment or fine. Then absolute liability. So liability without proof of fault or negligence, strict responsibility. This is called as liabilities. Then acts, mens rea, negligence. So we'll discuss acts and conduct. So act is voluntary bodily movement producing legal consequences. Here, omission can also constitute act in law. Okay, mens rea, guilty mind, criminal intent to necessary for criminal liabilities. So actus on facit reum nisi mens citria. Then intention and motive. So intention is a immediate purpose of act. Motive, ultimate reason, generally irrelevant in law. So negligence. So breach of duty of care causing damage. Failure to exercise reasonable care expected from prudent person. Then kinds of liability. So strict liability. So liability without fault. Okay, applies in dangerous uh, activities. Rule in Raylands versus Fletcher. Then accident. It is a unintended occurrence without negligence or mens rea, generally exempt from liability. Then vicarious liability. So liability for acts of another, master liable for servants act in course of employment. It is called as vicarious liability. Then measures of liability, civil compensation of actual loss, criminal uh, punishment appropriate, proportionate to offense severity. These are kinds of liability. Then ownership. It is a part of Unit 5. Definition: right to exclusive possession, use and disposal property. This is called as uh, ownership. Corporeal, corporeal ownership, ownership of tangible material object. Incorporeal ownership, ownership of intangible rights like patents and copyrights. Sole ownership, vested in single person exclusively. Co-ownership, shared ownership by multiple persons. Then possession. Okay, meaning and elements. So physical control over property with intention to exercise control. Okay, so these are two types: corpus possessions, okay, that is physical elements, then animus possidendi, this is mental elements. Okay, then ownership versus possession. Ownership is right, possession is the fact. Owner not possesses, but possessor may not own. Okay, possession is prima facie evidence of ownership. So possessory remedies. So legal protection given to possession through actions like recovery of possessions, damages, and injunctions. So this is a possession. Okay, property, justice, criminal justice theories. Property. So movable, immovable, tangible, intangible, acquired through possession, prescription, succession, transfer. Okay. Then justice, fair treatment to law, justice, civil justice, disputes between individuals, criminal justice, offense against society. Then deterrent theory, punishment prevents future crimes through fear. Then uh, preventive theory, disables offender from committing further crimes. Then reformative theory, so reforms criminal into law abiding citizen. Then Re- Retributive theory, punishment as revenge, eyes for eyes principle. So this is about the jurisprudence. Go through this. If you are newly watching, please do subscribe and share, like. Thank you for watching. We'll meet in the next class. Thank you.